parties, starting with respondent.
Yes, presiding arbitrator, my name is Miguel Cosio, and I will be discussing the procedural issues on behalf of Darwin Natural Food, PLC respondent.
Thank you. Counsel for claimant jurisdiction.
Good afternoon, Mr. Presiding Arbitrator. My name is Thais Crudo, and I will be presenting the procedural issues on behalf of claimant for GIFs Worldwide Ltd. Thank you.
Thank you. Counsel for claimant merits.
Hi, I'm Martina Rez. I'm here on behalf of claimant, and I will present the merits of this.
Thank you so much. And finally, counsel for respondent merits.
Thank you. Good afternoon. My name is Valeria Franco, and today I'll be pleading the merits of this case on behalf of respondent.
Thank you so much. So, does the parties have agreed on the allocation of times?
Yes.
Okay.
Go ahead.
Mr. President, thank you. Yes, the parties agreed to allocate 14 minutes for the main pleading, leaving 1 minute for rebuttal and rebuttal. And as the order of the proceeding, respondent will start with the procedural matters, followed by claimant. Then claimant will start with the merits of the case, followed by respondent.
Okay, perfect. Thank you so much, Thais. So, if there's nothing more to say before starting the hearing, counsel for respondent jurisdiction, the floor is yours for the next 14 minutes. I truly encourage all of the pleaders to stick to the 14 minutes agreed by the parties. So say that you have 14 minutes and the time will start running at the time you start talking.
Thank you, and good afternoon from Mexico, presiding arbitrator, members of this tribunal, opposing counsel, and all the public here present. As said, we represent the interests of Darwin Natural Food, PLC respondent. Members of the tribunal, this arbitration is a bet for the funder, and its interest and control generates concerns. Allow me to recall two relevant facts to assist this tribunal to understand the procedural issues we will be further discussing. First, the conclusion of a contract for the sale of orchids between the parties on the 25th of August 2022, agreeing to arbitrate any dispute under the current arbitration rules. And second, the commencement of this arbitration on July 2025, and also by claimant disclosing the existence of two funders, ATJ Financing and Literature. We have two submissions. First, that the SIAC Rules 2025 are the applicables to this arbitration. And second, that the disclosure is fit for a security for cost application. Moving on to our first submission, the SIAC 2025 are the applicable rules to this arbitration for three reasons. First, because that set of rules apply by default. Second, because it was not otherwise agreed by the parties. And third, because the arbitration commenced on 2025. Moving to our first point, according to Rule 1.5 of the SIAC Rules 2025, any arbitration commenced after the 1st of January 2025 should be governed by the SIAC Rules 2025 unless otherwise agreed. And that leads to the second point. The parties did not agree otherwise. To assist this tribunal to understand what agreeing otherwise means, I will recall one relevant precedent. It was a case before the Singapore High Court on 2015 between AQC and ARA. In this arbitration, court and litigation that come from a previously arbitration in which the plaintiff applied for setting aside an award on the basis that the parties did not agree to the rules enforced at the commencement of the arbitration, but rather to the rules enforced at the conclusion of the contract. The court was sized by the same question that we are to resolve in today's pleading. Which set of rules was the ones that the parties agreed to? That in that case, we're talking about the 2007 SIEC rules against the 2010 SIEC rules. The court held that the applicable rules were the ones enforced at the commencement of the arbitration, considering the 2007 rules were not specifically agreed. That means, and the rationale was, that if the parties really intend to apply the rules in force at the conclusion of the contract, they could easily identify that set of rules, considering that set of rules, it already exists at that moment. So any lack of specificity should be understood as referring to the rules at the commencement of the arbitration. This case may assist this tribunal to rule on the decision regarding the applicable rules, as we are sized by the same question, whether to apply 2016 SIEC rules or whether to interpret current as the rules in force at the commencement of the arbitration. And said so, I will move to the third point of the first submission, that is, when did the arbitration commence? The answer to that question, I will refer this tribunal to the page 24 of the bundle, page 26 of the digital version. Is this tribunal with me? Thank you. I refer to the second paragraph, and I quote, "The registrar of the Court of Arbitration of the SIAC has determined that this arbitration has commenced on the 31 of July 2025. We can appreciate that the registrar already pronounced on when and in what specific date did the arbitration commence, in this case, 2025. And for these three reasons, we submit to this tribunal that the applicable rules are the 2025 SIAC rules, since they apply by default, and it was not agreed otherwise. And thirdly, the arbitration commenced on July 2025. Now,
Counsel, I have a question there. So you mentioned that the register expressly mentions that the arbitration started in 2025, but is that annotation binding to this tribunal? Or could this tribunal determine that the arbitration initiated, let's say, with the initiation of the mediation?
Mr. Arbitrator, that provision is binding to this tribunal, considering that is in accordance with the Rule 6.2 of the 2025 SIEC rules, which provides that the arbitration should be deemed to commence at the moment the registrar receives the notice for arbitration. So this act should be understood at that, according with that rule, that the arbitration commenced on that date. Now I will move forward to the second of the submissions, that it is.
Sorry, Counsel. I have a follow-up question. Could you please address why the prior negotiations with Botanical Garden should not be attributable to respondent? I mean, considering that Botanical's representative who gave the meaning to the term current by referring to the 2016 rules, right?
Madam Arbitrator, to answer that question, I will refer to the page 10 of the bundle. That will be the page 12 of the PDF version, specifically to the recitals at the beginning of the sales agreement between the parties. Is the tribunal with me? I quote, "The agreement replaces the early agreement between the seller and Botanical Garden of Equatoriana concluded on the 1st of December 2021, which is hereby terminated. We appreciate from this wording, Madam Arbitrator, that the parties terminated previous contract and that the parties are different parties. Botanical Garden is different from respondent, and that intention should not be binding for respondent."
So I have a question there. Could this tribunal consider that the first contract, meaning the contract between the Botanical Garden and claimant, can be actually binding to respondent? Let me explain. I think that this first contract was concluded in the interest of respondent. So could this tribunal bind respondent like under a theory of, I don't know, agency or ostensible authority, estoppel? I don't know if I made myself clear.
Mr. Arbitrator, we we sustain this idea that since the previous agreement was terminated, and I would like to support my idea by referring also to the clause 2.4 on the same page of the bundle, that it says the exclusive terms of this agreement constitute the exclusive terms governing the sale and purchase of goods. Mr. Arbitrator, the previous agreement not only was terminated, but also we have different parties to this contract, and there was an intention of respondent and claimant of having a clause that excludes all other terms that should govern this commercial relationship.
Counsel, I have two questions. First one, why do you consider that Botanical Garden and your clients are different legal persons if respondent assume all the liabilities and rights of Botanical Garden, and it is stated in the bundle? And second one, do you consider that the recital included in the first page of the sales agreement is sufficient in order to conclude or terminate a previous contract? Why can't this arbitral tribunal don't consider that it was an amendment rather than a novation of the obligations?
Mr. Arbitrator, I will answer to your question in the order where those questions were made. Answer to the first question, even though respondent has took over the ownership of Botanical Garden, this contract is completely different from the previous contract. So indeed, there was a commitment of having the liabilities of Botanical Garden. However, this contract is different. The number and the quantity of and the object of this contract are completely different. We have 3,300 vanilla orchids. Relevant issues to the contract were changed and modified. There was an explosion of the previous contract. And answering to the second of your questions, that whether if the drafting and the wording of the recital is enough, it is respondent's position that the drafting of this recital is enough, considering the termination of the previous contract that constitutes the difference between an novation and an amendment of a contract. Said so, I will move to our second submission, that is the disclosure is fit for assessing a security for cost application. This arbitral tribunal has the power to order the disclosure of the two external funding arrangements concluded by claimant, according to Rule 38.4 of the SIAC Rules 2025. That rule provides that the arbitral tribunal has the power to order the disclosure of any detail of the funders' agreements as it sees fit. It is respondent submissions that the AT policy is fit for this arbitral tribunal to assess the degree of commitment that the funder, in this case, Literature, has over adverse costs. And it also fit for addressing the degree of control that was conceded to ATA financing in the third-party funding agreement. These 2 points are relevant to address whether a respondent should apply for a security for cost. Regarding the second point, the AT policy is fit to address the degree of commitment of ATE Literature. First, we agree and we understand that the ATE policy between Literature and claimant was executed for protecting claimant of any adverse cost that may be ordered against it in case it loses the case. However, according to Nivelt and Victoria Sahani in the third-party funding international arbitration book, and specializes authority in that matter as third-party funding.
Excuse me, counsel, who's Victoria Sahani?
Victoria Sahani is a professor for the University of Boston that has dedicated a very substantial part of its professional career to the study of third-party funding. And in its book, it provides that the external funding arrangements may be limited by walking out clauses. Members of the tribunal, a walking out clause is a clause that allows a funder to walk out of the funding if it is convenient for its interest. Therefore, even though the AT policy protects adverse costs, respondent has concerns whether if the funder Literature will be able of walking out of that funding, leaving claimant.
Counsel, are you aware that such type of clause was included in the TPF agreements?
Mr. Arbitrator, we have no certainty that such clause was included, and that's precisely the reason why we request the disclosure of the agreements. And
don't you consider that that may give you some advantage over your opposing counsel's clients?
we consider that it is necessary for a respondent to properly manage its arbitration rights and its strategy, considering the necessity and insolvency that claimant is about to incur on.
Does your opposing counsel's client is insolvent?
Mr. Arbitrator, since my time is about to lapse, I would like to request 1 extra minute to answer that question.
I will grant you only 30 seconds, so hurry up.
Mr. Arbitrator, claimant is insolvent as we can appreciate from the answer to the question in the procedural order number 2, the answer to the question number 20 on page 58 of the bundle. I will refer this tribunal to the page 20, and the question was whether if claimant will pursue the present claim without the financial support of 8K funding. I refer to the third line to the answer to the question. Is the tribunal with me?
Yes.
I quote, claimant's insurance likely will not cover the losses, leaving claimant solvent only until June 2026. We can appreciate that claimant is running into insolvency, Mr. Arbitrator, and for that reason, the disclosure of AT policy should be granted. And regarding the third-party funding agreement, it is also relevant to assess correctly this financial status and these financial issues that claimant is having. For these reasons, considering that the 2025 rules apply by default and external funding arrangements are fit to assess security for cost, we request the submissions, and with I terminate my pleading.
Thank you so much, counsel, for respondent jurisdiction. Before moving on to counsel for claimant jurisdiction, I don't know what's happening with my camera, so I apologize for having that camera off, but I am here, okay? And second, in order to guarantee the quality of arms for both parties, I'll grant a counsel for claimant jurisdiction 30 seconds more to the agreed time. Do you accept such time, counsel?
Yes, thank you, Mr. Presiding Arbitrator.
Thank you. So, said that, please, counsel for claimant jurisdiction, the floor is yours for the next 40.5 minutes. And the time will start running at the time you start talking.
Thank you. Members of the tribunal, what respondent has argued is just one part of the story. A proper reading of the record leads to a different conclusion. Vanilla orchids grow in stable conditions. You don't change the soil once the plant has taken root. Yet respondent now asks this tribunal to apply a different set of rules that did not exist when the consent to arbitrate was given by the parties. When the sale agreement was concluded, it was done under an agreed procedural rules. Those rules were the SIAC Rules 2016. They were known, they were part of the agreement when the consent to arbitrate was given. As for financing, there is no uncertainty. Claimant has an adverse cost insurance and a third-party funder in place. The final risks, so then, are covered. For the convenience of the tribunal, I would mirror the structure proposed by opposing counsel by arguing that, first, the SIAC Rules 2016 govern this arbitration. Second, the disclosure of the third-party funding agreement and the literature insurance contract shouldn't be ordered. Turning to claimant first submission, opposing party started saying that by default, the 2016 version of the rules should apply. However, if the parties intended to adopt the rules in force at the time the arbitration began, a clear and unknown formula was able to done. The SIAC model clause refers specifically for the rules at the time for being enforced. In international arbitration, that expression is understood as a dynamic reference, meaning that the rules in force when the arbitration begins should apply. However, the parties did not use that wording. Instead, they deliberately refers to the current SIAC rules. They choose a static reference to the rules at the time of contracting. So the term current naturally refers to what exists in a particular point in time, and in that context, in the context of contractual consent, that point is when the parties agreed to arbitrate. This understanding is also reinforced by the Parties Court of Appeals in SNF SAS versus ICC, which held that the incorporation of institutional rules is determined at the time the contract is concluded.
Counsel, I have a question there. So your position is that the intention of the parties was to apply or to freeze this clause as to apply the 2016 rules. Is that correct?
Exactly, Mr. Arbitrator.
Okay, so then why didn't the parties expressly state it so? If their intention was actually for 2016 to apply, why didn't they apply it or they drafted the clause so it would say 2016 and use such an ambiguous term as current?
Mr. Arbitrator, I see your point. However, it wasn't necessary for the parties to expressly recognize that the 2016 version should apply, since if the tribunal could follow me to procedural order number 2, specifically on page no, why would I remember? Wait a second, please. Specifically to page 56 in clarification 7, the third line from the bottom to the top is the tribunal with me. Okay, so there I quote, Mrs. Cobley also added a reference to the current arbitration rules, which were the ones she had read. End of the quote. There, it is clear that at that moment, the only rules available for Mrs. Cobley to read were the SIC Rules 2016. So it wasn't necessary for the parties to make an express reference to the version that should apply to the case. But it's more, opposing counsel tried to argue that by using the word terminated in the preamble of the contract, the negotiations won't be attributed to respondents. However, under the doctrine of separability, an arbitration agreement is legally independent from the main contract. The determination or replacement of the substantive agreement does not on its own terminate the arbitration clause.
Counsel, excuse me to interrupt you. Talking about this separability principle, do you is there any deviation from such principle when the parties agreed to employ the CIG in order to interpret both, well, the arbitration agreement and the contract stated in the PO1 or Procedural Order 1?
Mr. Arbitrator, there is no deviation in interpreting the arbitration clause. However, the conclusion reached by the doctrine of separability is further reinforced by Article 8.3 of the CISG, since it further confirms this conclusion of respondent's subsequent conduct, since respondent expressly took over Botanical Garden, including all its commitments and liabilities, and therefore stepped into its contractual position with full knowledge of the existing framework, since had total access to Botanical's email server. What is more, when the contract was amended on 25 August 2022, respondent modified commercial terms, but deliberately left the dispute resolution clause unchanged. So that means that there was a selective amended, shows that respondent was aware of the clause, had the opportunity to renegotiate it, and chose not to do so. As a consequence, having accepted the contract as a whole, respondents cannot now seek to apart itself from the arbitration clause. What is more, this approach is further confirmed by the Swiss Federal Supreme Court's decision, which confirms that successor parties are bound by existing contractual terms unless they expressly agree otherwise. Having this in mind, I would ask the tribunal to join me at page 21 of the record. Third paragraph, second line.
Excuse me, which page?
21.
Thank you so much.
In the third paragraph, second line, I quote, "The initiation of mediation proceedings should be treated for the purpose of a statute of limitations as constituting the commencement of arbitration proceedings." End of the quote. In other words, the parties expressly attributed to mediation the procedural effect of commencing arbitration. Opposing counsels argued that the parties did not agree otherwise regarding the commencement of the arbitration. However, what the tribunal just read reflects precisely what Article 21 of the Danubian arbitration law permits. Under that provision, the parties are allowed to determine when the dispute is deemed to commence. That is exactly why they did. The parties modified the MAA protocol. They agreed that mediation would be the first step of the arbitration of the proceeding, and that could interrupt the statute of limitations. As a result, the first procedural step of a single integrated dispute resolution framework. Most importantly,
excuse me, talking about this MAA protocol, I have one doubt. If I am not mistaken, the record states that the parties agreed to include this protocol in order to have like a settlement coming from the mediation. Am I correct?
yes, Mr. Presiding Arbitrator.
And in that case, then such settlement will be elevated to an award issued by an arbitral tribunal.
Exactly.
Okay, so my question is, how does that probable award may be issued if at the moment, in any case, the parties had agreed a settlement, if there was no arbitral tribunal constituted?
Mr. Arbitrator, I see your concern. However, this is what the parties' autonomy allows the parties to do. In specific, the parties agreed that the enforceability of a settlement reached in arbitration can be converted into an award and enforced under the New York Convention. So that is why also claimant states that mediation cannot be characterized as a legally separate or self-contained phase. It is integrated into
Excuse me,
the.
counsel. I had another doubt in this part. Does a settlement coming from mediation can be binding for the parties? I mean, more than binding, can be enforced by any authority?
Yes, Mr. Arbitrator, if a settlement is reached in mediation, then it can be, in this present case, and regarding to what the parties agreed, then it can be enforceable under the New York Convention.
I mean, it can be enforced by coercive or with coercive powers?
Yes, Mr. Arbitrator. I mean, the parties agreed that it can be enforceable under the New York Convention. So why then it cannot be enforceable?
And I have a follow-up. I'm sorry. I have a follow-up question. What do you mean about it enforcing by the New York Convention?
That then the parties can I mean, when they obtain the award, it becomes enforceable, like to make them, I can't come up with the word. I mean, it is enforceable under the New York Convention, and it's a settlement that then has the same legal effect as an arbitral award. So that is what I mean. So following to claimant's second submission, opposing party argued that the disclosure of the third-party funding agreement should be ordered in order to assess security for costs. However, first of all, and related to claimant's first submission under the SIC Rules 2016, there is no express provision that empowers the tribunal to order the full disclosure of the third-party funding agreement. What is more, when respondent argues that disclosure is necessary in view of application for security for cost, that argument also fails. Security for cost is an exceptional provision measure. It is intended to protect a party's right to recover costs only where there is a proven and real risk that the opposing party will be unable to comply with an adverse cost award. However, the requirement to order security for cost is not made here. Why? The main reason is that claimant isn't insolvency. I mean, there, here, in the present case, is no evidence of present insolvency. The record refers only a possible future uncertainty as from June 2026. Security for cost addresses inability to pay, not speculation about what might happen at some later stage, as respondent as this tribunal to take into account. Moreover, any potential adverse costs are covered by claimant after the event insurance policy with lead sure. In other words, even if the tribunal were concerned about a future recovery, that risk had already been neutralized. So, if the tribunal had no further questions, claimant respectfully submits that the 2016 version govern this arbitration proceeding and not to order the full disclosure of the third-party funding agreement. That leads to the end of my arguments. Thank you.
I have a question, counsel,
Okay.
regarding your submission. So for me, it's not that clear. Why is it important for your client for this tribunal to apply 2016 rules?
Mr. Arbitrator, first of all, it is important to apply the 2016 version of the rules as they were the only rules known by both parties at the time of contracting.
No, let me rephrase my question. I mean, I already understood like the arguments as why should we apply the 2016 rules. For me, it is clear and they are quite compelling arguments. But why is it important for your client for us to apply those rules? I mean, what would it change the proceedings or why does your client have an interest for this tribunal to apply those rules?
Mr. Arbitrator, well, regarding the proceeding, first of all, in the 2016 version, there is no express provision that the tribunal has the power to order the full disclosure of the third-party funding agreement, whereas in the 2025 version, there is an explicit rule that empowers the tribunal to order it. So that will be the main reason for not applying the 2016 version, for not applying the 2025 version, since not only that version was unknown to both parties, not only for claimant, but also because now that it empowers the tribunal and as a consequence benefit respondent and not claimant, well, we consider that it shouldn't apply.
So if this tribunal decides to apply 2025, then we wouldn't have powers to order the disclosure?
If the tribunal decides to apply the 2025 version, as opposing counsel argued, there is Article 38.4 that empowers the tribunal. However, that article cannot be read in isolation or beyond its limits, since the rules provide that the tribunal may order the disclosure of additional details, but it uses the word may. So it is decisive that the disclosure shouldn't be mandatory but discretionary. And usually disclosure is ordered to assess security for cost or to assess a conflict of interest. Since in this case, neither of those are present, so the disclosure shouldn't be ordered.
Okay. Thank you, counsel.
Thank you.
Well, thank you, counsel, for jurisdiction of both sides. Um, I think we can move on to the rebuttal and sub-rebuttal. So, counsel for respondent jurisdiction, you will have 1 minute for rebuttal. Then the clock will start running at the time you start talking.
Thank you. As shown by arbitrator's Lovato question, the only ground of claimant's argument is convenience. Convenience of having the application of a rules that does not expressly recognizes the arbitral tribunal's power. However, that power could be found in the inherent power to conduct the proceedings. Thank you.
Okay, thank you, counsel. So, counsel for claimant jurisdiction, you will have 1 minute, and you can start talking at whenever you want.
It is not about, thank you. It is not about convenience as opposing counsel tried to argue. It is about respecting the parties' agreed procedural framework and to apply what was known to both parties at the time of contracting. Thank you.
Thank you, counsel. So I think we have finished with the procedural part of this hearing. Now, I think it's time for counsel for claimant merits. Counsel Martina, I think it is. So, counsel for claimant merits, excuse me, the floor is yours for the next 14 minutes.
Thank you, members of this tribunal. Once again, on behalf of Orchids Worldwide Ltd, my name is Martina Bres, and I will discuss the merits part of the present case. Members of this tribunal, the parties terminated the sales agreement on March 1st, 2024, as a direct consequence of respondent's failure to perform its contractual obligations of obtaining the necessary import permits for the delivery of 3,300 vanilla orchids. Respondent now seeks to shield its conduct by invoking a non-existent Article 79 exemption. Due to respondent's breach, claimant is now seeking damages for the amount of $3,003,000, price calculated between the difference of the sales agreement and the cover sale concluded with Vale Cosmetics on February 15 of 2024. In light of these facts, claimant will make the following two submissions today. First, that claimant is entitled to damages due to respondent's breach, which is not excused under Article 79 of the CISG. And second, that claimant damages were correctly calculated according to Article 75 of the CISG. Turning into my first submission, claimant will demonstrate that respondent cannot avoid liability, as Article 79 of the CISG demands 4 cumulative conditions: an uncontrollable, unforeseeable, and unavoidable impediment to be the sole cause of non-performance. And in this case, respondent fails 3 out of 4. First, the impediment was foreseeable. The starting point here is clear and undisputed. If the tribunal might follow me into page 11 and 10 of the case file, that is the sales agreement between the parties. Is the tribunal with me? We can see that there was a valid contract entered into August 25th of 2022, for which claimant agreed on clause 2.1 to deliver 3,000 vanilla orchids, with a tolerance of 10% more or less, and respondent to obtain all necessary input permits, as it was clearly stated in clause 5.1 of the sales contract. Members of this tribunal, respondent cannot claim a surprise. Since September 2023, the CITES committee itself have warned that the vanilla orchid will be moved from Appendix 2 to Appendix 1. This was not a remote or extraordinary scenario. It was a concrete possibility within a dynamic environmental regime. In situations of risk of regulatory change foreseen at the time of contracting, courts often refuse Article 79. For example, in the Ukrainian coal case, where the seller failed to ship coal because of a ban on coal exports by the Ukrainian government, the arbitral tribunal concluded that a government export, whilst clarifying as an impediment beyond the parties' control under Article 79, if the remaining requirements are lacking, therefore no exemption was granted. Second, and the most important requirement, is that respondent could have avoided or overcome this impediment. Members of this tribunal, since the parties learned about this regulatory change concerning vanilla orchids, respondents did absolutely nothing to overcome or prevent this obstacle. They rejected the early delivery proposed by claimant in November 2023.
Counsel, excuse me. Only one question. Regarding the standard that you are addressing, does avoidability and overcomability are the same?
Sorry, Mr. Arbitrator, can you repeat the question for me again, please?
Yeah, sure. Under the standard that you are addressing, you mentioned the word avoidability and overcomable. I am asking you if they are the same.
Well, in this case, yes, because respondent did not avoid or try to overcome this obstacle. Respondent, unless the claimant's recommendation of bring an early delivery, decided to keep the delivery date as late as possible. That is March 27 of 2024. Furthermore, the parties discussed applying for an anticipatory input permit in November of 2023. Did respondent apply? No. Instead, they relied on their good contacts with the government of Ecuatoriana and the lenient practices of the government itself. This was a gamble. Respondent bet on their political influences rather than taking the safe legal route. And when that gamble failed, it became a breach of contract, not a force majeure event. Finally, the impediment was not the sole cause of the breach. Respondent had already decided to postpone the delivery, change its business strategy, and had chosen to divest from its spice business. As Professor Spencer states, if the impediment is not the only cause to perform, the exemption under Article 79 simply does not apply. Therefore, the regulatory change was at most a convenient factor, but not a decisive one. Members of this tribunal.
Sorry, Counsel, I have a question there. So if we see clause 12 of the contract, the parties expressly mentioned government measures.
Mm-hmm.
So could we think, or could this tribunal think that respondent could be exempted from this hypothesis under clause 12?
Counsel, only to add to my co-arbitrator's question, in your opinion, which clause or article prevails over the other, or how does they function together? I mean, which excuse me, which provision does this arbitral tribunal should apply or should consider? clause 12 of the agreement or Article 75, 79 of the CIG?
Okay, so I'm gonna answer first the first question that was asked and then the follow-up question. Mr. Presiding Arbitrator, the sites cannot be considered as government measures because it is not a governmental institution. Then the follow-up question, we submit that it should both clause 12 and article 79 be considered to consider if there was exception or not, because article 79 provides a threshold to tell if a party is exemption for liability or not. And clause 12 of the sales agreement is a taxative number of events that rely on respondent's exemption.
Council, sorry for taking you back to the first question, but isn't the CITES conference a multilateral governmental body?
Okay, then, Mr. Arbitrator, respondent itself had admitted that the impediment was site reclassification. However, claimant submits that it cannot rely on the site exemption because since September of 2023, there was a concrete possibility that it could change from Appendix 2 to Appendix 1, and the respondent did absolutely nothing to, did not take into account the recommendations of claimant. So we cannot rely on this exception because it was foreseeable. Turning into my second submission, claimant will demonstrate first, in contrary to what respondent argues, that the sale made with herbal cosmetics constitute a valid covered sale, as the requirement of Article 75 are met. And second, that the highest amount of vanilla orchids are the ones that should be taken into consideration for calculating damages. To start with my first point of this second submission, Article 75 of the CISG provides a method for calculating damages when the contract has been avoided and the affected party has entered into a subsidy transaction. For a subsidy transaction to be considered as such, three requirements must be met. There must be an avoidance of the contract, the agreed party must have made a substitute sale, and it should be reasonable in both time and quantity after the avoidance. And in this case, all three requirements are met. As for the third requirement, claimant will not argue about, since that problem was already solved in procedural order number 2, where it was stated, and I quote, insofar as the sale to herbal cosmetics can be classified in relation to time and quantities as a covered sale in the sense of Article 75 of the CISG, it can be considered reasonable. End of quote. Regarding the first requirement, it is important to clarify that since February 10 of 2024, respondent had already informed claimant that they were not going to fulfill their contractual obligations. Respondent not only failed to comply, but also put claimant in a situation where they had to act quickly to mitigate their losses. And that is exactly what claimant did. Members of this tribunal, why would claimant have to wait for a formal declaration of avoidance, since it was clear that the performance of the contract would not take place, as it is enough that the intention of non-performance is sufficiently clear and definitive for realizing a covered sale? In this case, the sale to herbal cosmetics negotiated immediately afterward and concluded on February 15 of 2024 was a direct and unnecessary response to respondents' non-compliance. Moving on into the second requirement for a covered sale to be considered as such, although the transaction with herbal cosmetics included a modification of a pre-existing contract, the immediate sale component is severable for Article 75 purposes. The parties documented two different obligations: the immediate sale of 3,300 vanilla orchids and a modified future supply. Therefore, and as a direct consequence...
Excuse me. On the articles that you are addressing, there's like a requirement that states that to consider a cover sale as, I don't know how to say it, legal maybe, and and voiding of the contract should be made before.
I
And
see your point.
if I am not wrong, your client did not avoid the contract before making the cover sale. So, what can you tell us about that?
Mr. Presiding Arbitrator, while it is true that the sale with Herbal Cosmetics was concluded before the official avoidance of the contract, Article 75 has exemptions for when the intention of non-performance of the other party is definitive and clear to make a cover sale. For example, in a similar case from the District Court for the Middle District of Florida, when the seller refused to send a contract to the buyer, the court considered this action as decisive and awarded damages on the substitute sale. There was no formal declaration of avoidance, but the court considered that the seller's repudiation amounted an avoidance, enabling the court sale.
Counsel, so is it your contention that this requirement of avoiding the contract before concluding the cover sale, it's a mere formality?
Well, Mr. Presiding Arbitrator, could you repeat the question for me, please?
Yeah, for sure. With what you are addressing to us at this moment, you quote us a resolution from U.S. court. Okay, so for you, these requirements of avoiding the contract, it's a mere formality. I mean,
No,
the parties can deviate from such requirement and jump up to the cover sale.
Mr. Arbitrator, if it is clear and definitive sorry, Mr. Arbitrator, I'm afraid I'm running out of time. Could you, may I ask for an extra minute to answer your question?
Yes.
If it is clear and definitive that the other party will not comply, then cover sales made before avoidance of the contract can be considered valid. In conclusion, the maximum delivery quantity of 3,300 vanilla orchids should be taken into consideration for calculating the damage of the problem. Members of this tribunal, in this case, the facts are very clear. Respondent did not comply with its obligations. It cannot rely on Article 79 and claimant correctly calculated damages under Article 75 of the CIG after a valid and reasonable cover sale. This is why claimant respectfully requests this tribunal to award full amount of $3,000,003,000 US dollars. Claimant is not asking for a benefit, a reward, or a shortcut. It is just asking for what the contract promise and the CISG guarantees when the contract is breached, that the buyer puts the seller exactly where they will be today if respondent have kept their word. That will be the end of my submissions.
Thank you, counsel. So I think we can move on to respondent side on merits. Counsel for merits, respondent counsel for merits, excuse me. Your opposing counsel took 15 minutes and 24 seconds. So you will be granted with the same time, 15 minutes and 24 seconds. Do you accept such time?
Yes.
Thank you so much. Even though I strongly encourage you to end in 14 minutes at most, please. Said that, the floor is yours, and the clock will start running at the time you start talking.
Thank you. Good afternoon, Mr. Presiding Arbitrator, members of this arbitral tribunal, opposing counsel, and all the public present at this hearing. Members of this arbitral tribunal, this case is not just about a breach of contract, not just about an impediment, but of a convenient case presented by claimant. Now,
Counsel, with this catchy phrase, you read my mind, and I would like you to respond. Does your client committed a breach of contract or several breaches of contract? It's a yes or no question.
Yes.
Perfect. Thank you.
Allow me to recall to this arbitral tribunal some of the relevant facts that my opposing counsel failed to mention. First, it was the contract concluded on the 25th August 2022. Yet, the recommendation from the CITES committee was done on September 2023, that is almost a year after the conclusion of the contract. The actual moving of the Vanilla Orchids to Appendix 1 occurred almost a year and a half later from the conclusion of the contract. And the cover seal was concluded on the 15th February 2024. Now, mirroring my opposing counsel structure, I will divide my submission into first, that respondent is exempted from liability, and second, that the calculation cannot be done as claimant suggested. Moving on to my first argument, or to my first submission, I will divide it in first, that the impediment was unforeseeable at the time of the conclusion of the contract. Second, it was unavoidable. And third, it was beyond the sphere of control of my client. Moving on to my first argument, the impediment was not foreseeable at the time of the conclusion of the contract. As clearly stated by my opposing counsel, Article 79 of the CISG suggests or has to meet 3 requirements in order to be exempted from liability. But it failed to mention that for an impediment to not be exempted, it has to be not foreseen or it has to be foreseen at the time of the conclusion of the contract. My opposing counsel only mentioned that it has to be foreseeable, but not when. It is important that it has to be at the time of the conclusion of the contract. Foreseeability does not mean that any impediment, for example, as mentioned under the force majeure clause, has to be prevented or has to be foreseen. There has to be a control under that foreseeable. Yet, it was not foreseeable.
Also, excuse me. In this regard, let me ask you the same question I made to your opposing counsel. That was this arbitral tribunal, which provision does this arbitral tribunal should take into account? Articles 75, 79 of the CISG or clause 12 of the agreement? Or how do they work together?
Both Article 79 of the CIG and the force majeure clause complement each other. They do not derogate one another, they do not supplement one another, they just complement each other since they contain mostly the same requisites from them. Now, continuing with my argument, there has to be a certain...
Counsel, why, if there was a possibility that the vanilla orchids could be moved from Appendix 1 to Appendix 2, did your client not obtain the import permits? I mean, if you are arguing that the foreseeable has to be at the time of the conclusion of the contract, I mean, at that moment, it was already the possibility that the vanilla orchids could be moved, right?
In order to answer to your question, I will recall some of the relevant facts to the case. The contract was concluded on the 25th August 2022, and then the first recommendation of the vanilla orchids to move into Appendix 1 occurred a year later on September 2023. That is not at the time of the conclusion of the contract. Yet, it is known that a respondent could have taken into account such recommendation. Yet, it was just a mere recommendation. And there is also a relevant fact in which there was a conference, a never invoked conference.
Excuse me, counsel. However, and adding to Madame Arbitrator's question, there was a window of between 5 and or 6 months between the moment where the news of the probable moving from Appendix 2 to Appendix 1 of the orchids would happen to the moment of the conclusion of the obligations. So I think it was pretty reasonable for your client to obtain in such windows the permits.
Respondents still believe that in any case, the change of the vanilla orchids to Appendix 1 occurred it would still fall under that 90-day period of the amendments done to the CITES convention. Even if the impediment arose, respondent would still have enough time to apply for an input permit. Yet, there was an immediate effect done under such convention, which was never invoked before and even to that extent could not have been foreseen. Now, moving on to my second argument, the impediment could not
Sorry, counsel. Sorry. And why did your client assume the responsibility to get the import permits under the clause 5.1 of the agreement?
Respondent assured to obtain the import permits, but never was obliged to apply to an anticipatory permit. Yet, this obligation under clause 5.1 is just a mere obligation of measure. It is not a result obligation. So, this anticipatory import permit for which respondent allegedly should have applied is just not its obligation. And even respondent tried had its best efforts to try to comply with its obligations when it had noticed that impediment was going to be done. Yet, moving on to the second argument, the impediment could not have been avoided. For an impediment to be avoided, there has to be, again, to try to take all possible options in order to prevent that impediment from happening. Respondent
Counsel, before you continue your submission, let me ask you the same question I made to your opposing counsel. Does avoidability and overcomability are the same?
No, Mr. Presiding Arbitrator. Avoidability is such in which you could prevent from a non-performance of an impediment or a non-performance of obligations before the conclusion of the contract. And to overcome an impediment means that it has to be done after the conclusion of the contract or after the impediment arose. So no.
Okay.
No.
Thank you so much, counsel. And in this case, which one of both are the one that this arbitral tribunal may consider?
The overcomability, yet it could not have been avoided at all.
Okay, why? Please, well, continue, please.
Thank you. Respondent had several internal discussions regarding a possible early delivery, regarding applying for an anticipatory for an import permit, or when it would have taken delivery of the vanilla orchids. Respondent take all the reasonable measures in order to try to avoid or to overcome the impediment. Yet, neither option was viable. Moving
Counsel,
on.
I have a quick question there. So correct me if I'm wrong, but claimant proposed to your client to an early delivery, is that right?
That's right.
And why did respondent reject that early delivery?
Arbitrator, to answer to your question, I will invite this arbitral tribunal to go to page 15 of the case bundle, which is exhibit C5.
Okay.
This is an email from Edmund Alves to Georgia Theophrastus. On the third paragraph, line 5, is this arbitral tribunal with me?
Yes.
I quote, any earlier delivery would put at least 2/3 of the vanilla orchids to be delivered at risk, as they would have to be stored at commercially unreasonable costs in one of the existing greenhouses and would then have to be moved to the new greenhouse, exposing them to additional stress. An early delivery was not viable for neither of the parties.
So basically the reason why you didn't accept the early delivery is for commercial reasons. Am I right?
No. An early delivery was not accepted since first, 2/3 of the vanilla orchids would have been damaged, and that would put them under additional stress. So 2/3, 60% of the vanilla orchids would have been damaged and would not have been possible to take any subsequential sale if they were damaged. And it was viable, or it was not viable, since both parties wanted to maintain the market price of the vanilla orchids.
But under Article 79 of the CSG, is a party excused by I mean, does Article 29 excuse a party who could have avoided the impediment but chose not to do so under convenience or commercial reasons? That's my question.
Yes, actually, there has been doctrine in which Article 79 exempts a party even if an impediment was not sufficiently economically to prevent the party from performing, but when it is considered that such performance is both damaging for both parties, they must be or they can be exempted of liability. This is supported by Christoph Bronner on his book Force Majeure Clause in Hardship, in which it states that when an impediment is not convenient or when where the compliance of obligations is not convenient for both parties, even though it's not for any requirement under Article 79, they can still be exempted. Now,
Council, does force majeure and hardship are the same?
no, Mr. Presiding Arbitrator, force majeure refers to an impediment in which the parties could not have been aware of, and hardship refers to an economic impediment. When such impediment is so economic that the parties could not comply or it is such damaging that it cannot be possible to perform under the contract. Now,
Counsel, you're admitting that your client breached the contract for convenience.
I'm sorry, could you please restate your question?
Yes, that you are admitting that your client breached the contract only for convenience.
No. I answered to the question of Mr. Presiding Arbitrator of which was the difference between force majeure and hardship. In this case, force majeure applies, and respondent is exempted since the impediment was unavoidable, unforeseeable at the time of the conclusion of the contract, and was beyond the sphere of control, not because of an economic impediment. Now, moving on to my second submission, my opposing counsel mentioned that the damages shall be calculated under Article 75 of the CIUC. Yet, it failed to mention many relevant facts. First, allow me to bring this arbitral tribunal attention page 39 of the case bundle, which is Exhibit R3.
Sorry, counsel, which page?
39. 41 of the PDF file. Is this arbitral tribunal with me? This is an email from Georgia Theophrastus to Edmund Albius regarding the avoidance of the agreement. Under the third paragraph, first line, I quote, "As indicated by Mr. Harman, Ortiz will try to sell the vanilla orchids, which have been reserved for you, to another entity as soon as possible." This email is from the 1st March 2024. And again, it is mentioned that Ortiz will try to sell the vanilla orchids. Yet, my opposing counsel mentioned that the coverage was concluded on the 15th February 2024. How come it mentions Ortiz will try to sell the vanilla orchids and at the same time states that a coverage has already been concluded? This makes no sense. How come the avoidance could not have been done before if it only takes for an email to inform of such avoidance? Yet, this avoidance is not done in a proper manner since it still maintained the contractual relationship between the parties, and it gave legal uncertainty to my client. Now, for the foregoing reasons or the aforementioned reasons, I request this arbitral tribunal to first apply the SIAC 2025 rules. Second, that the disclosure is fit to assess the security for cost. Third, that respondent is exempted from liability. And second, that the calculation of damages cannot be done under the way claimant proposes.
Thank you, counsel. Okay, so let's move on to the rebuttal of counsel for claimant merits. The floor is yours.
Members of this tribunal, the impediment was not unforeseeable. At the time of contracting, the parties agreed clause 5.1 to prevent situations exactly like this at hand. So if or when it happened, the parties already had a solution. This impediment is not unforeseeable. It is a direct breach of the contract by respondent. Thank you.
Thank you, counsel. Okay. Counsel for respondent merits, the floor is yours.
Thank you. This case is again not about breach of contract, but claimant is still arguing facts that are not demonstrated by my opposing party. So, in order for a party to mention the necessity to apply something to this arbitral tribunal, they have to be proven.
Santi, ¿estás ahí?
Oh, I'm sorry, I had the the mic off. I was I was asking you that with this, I think we have ended the hearing for today, and I would only like to ask you, well, both parties, if you feel that you have been treated in the same way, that you have been granted of the with equal treatment and the opportunity to present your case. So, counsel for respondent.
Yes, we feel we have been treated equally. Thank you, Mr. President Arbitrator.
Thank you, counsel. Counsel for claimant.
Yes, we feel that it was very equal. Thank you.
Thank you.
Thank you, counsel. So the award will be issued tomorrow. So you only have to expect it at that moment. Bueno, creo que ya podemos switchar a español si les parece bien. Oye, yo sé, no sé qué te parezca. Primero, si quieres que demos el feedback en español y en inglés, yo creo que podríamos darlo en
Sí,
español.
sí.
Va que va. Y la segunda es, si te parece bien que el feedback lo demos al otro equipo y ya internamente por aparte
Dale,
lo damos, o sea, cada quien a su equipo.
dale, obvio.
Va que va, me parece súper bien. Entonces, pues, si quieres, José, pues adelante.
Dale. Bueno, no me acuerdo. Franco es tu nombre. Bueno, Franco, al principio una cuestión de formalidad, las manos de ambos estaban abajo, después las subieron y bien con el tema de las manos, bien también el equipo, cómo se manejaron. A mí, pero es una cuestión propia, yo sí igual de merits, así que juris lo tengo ahí más flojo. El tema de la palabra current y cómo se interpreta y todo eso es medio que no me da todavía tanta seguridad, pero me gustó mucho cuando te preguntó, creo que fue Santiago, que te preguntó, diste una buena respuesta, o sea, fue convincente por lo menos, así que eso me gustó mucho. Tenés buen pace también, hablas con mucha seguridad, así que la verdad que felicitaciones. Para que estoy viendo a ver si anoté algo más. No me acuerdo mucho el rebuttal que hiciste, pero acá noté que por ahí estuvo un poquito largo, que yo lo hubiese hecho más corto, pero bueno, estuvo muy bien igual. Y con respecto a Valeria, el tema de no sé si me entendiste bien la pregunta del tema de lo que fue que existía una posibilidad, digamos, de que las orquídeas sean movidas al apéndice 2. Entonces, ¿qué pasaba con respecto a eso? Es decir, si habría algún tipo de previsibilidad por parte del respondent. Me gustó, no me acuerdo, creo que yo te hice una pregunta con respecto a qué pasaba con la cláusula 5 del contrato, porque vos asumiste la responsabilidad. Me gustó que me dijiste, o sea, creo que es una respuesta que se puede mejorar, pero para zafar en el momento me gustó que me hayas dicho que era una obligación de medios y no de resultados, porque en cierta forma es verdad, así que eso me gustó. Y lo que sí yo trabajaría un poco más es en el tema de la pregunta que te hizo Francisco con respecto a qué pasa con la conveniencia, porque a mí digamos, con el tema de la conveniencia en términos comerciales y económicos, porque a mí lo primero que se me viene a la mente es como diciendo, bueno, me estás admitiendo en realidad que vos rompiste el contrato por una cuestión meramente de conveniencia. Entonces, por ahí yo trabajaría un poco más en esa respuesta. Lo mismo que Franco, me gustó mucho la estructura, sos muy estructurada. Otra cosa más en materia formal, cuando te preguntan algo, yo diría más que no tan así directo, no, Mr. Arbitrator, o porque por ahí decís no y es como que nosotros no pasa nada, pero un árbitro ya más formal por ahí lo toma medio rude, entonces, bueno, por las dudas para. Pero bueno, son cuestiones formales. En general, muy bien, chicos. La verdad que felicitaciones, estuvieron muy bien los dos.
Muchas gracias.
Gracias.
Si quieres, Santi, me sigo yo.
Sí, sí, adelante y gracias, José, por el feedback.
Entonces empiezo contigo, Tai. Em, Me gustó bastante tu catchphrase. Pensé que no ibas a decir, porque creo que, o sea, por ahí sentí que ibas ya como directo a hechos, pero después soltaste la catchphrase y me gustó bastante. Ese tipo de catchphrase siempre son buenas, ¿no? Como hacer una analogía para atrapar la atención del tribunal. Entonces, eso muy bien. En algún momento que te estamos preguntando, vi que como que le quitaste el caso a tu compañera para buscar algo del caso, creo. Entonces, intenta evitar eso, intenta, digamos, siempre confiar en tu compañera y que ella te encuentre como la referencia, ¿no? Em, Me gustó mucho, o sea, creo que tienes un muy buen pace, siento que no te trabas, o sea, eres muy fluida y digo, obviamente es muy complicado considerando que no es el inglés nuestro primer idioma, entonces muchas felicidades por eso. Quizá a veces sí te sentí un poco trabada, pero ya era ya con preguntas. Entonces, creo que eso se quita, digamos, mientras más estudias el caso, mientras más estudias tus argumentos, poco a poco te lo vas a ir quitando eso, pero en general la ronda es que creo que fue bastante fluida. Em, lo que sí creo que es como el mayor, digamos, el foco rojo de tu pleading en particular fue y lo del New York Convention, que mencionaste, como que ahí la verdad el tribunal medio te enredó con preguntas. Em, Y si no estoy mal, creo que por ahí, bueno, entre todos te preguntamos, y en algún momento creo que dijiste que, digamos, el acuerdo que deriva de esa mediación podría ser enforceado en términos de la New York Convention, ¿no? Algo así, no sé si lo entendí, pero creo que algo así entendí. Como tal, como tal no, pero sí es cierto que hay una convención, la Convención de Singapur de mediación, que sería como el símil de la New York Convention, y entiendo que bajo esa convención sí podrías, digamos, intentar enforcearlo, pero pues en el caso no viene que que los estados sean signatarios de esa convención, entonces ahí nada más sería como, creo yo, como cambiar un poco la respuesta a esa pregunta. Eh, y otra cosa que creo que también sería muy bien que hubiera una respuesta preparada para eso es porque, a ver, denme un segundo, por favor.
No escucho nada. No escucho nada. Estaba re sorda yo.
Hola, hola, ¿me escuchan? Listo,
Ahí está.
perdón, es que me pidieron una cosita rapidísimo, pero bueno. Em, bueno, te estoy diciendo, creo que algo muy importante sería tener preparada una respuesta a la pregunta de por qué le interesa a Clayman que aplique 2016. Que sí me respondiste, o sea, sí me respondiste al final, pero la verdad es que luego este tipo de casos como muy doctrinales, o sea, siendo sinceros, como que a la fecha yo sigo sin entender por qué sería tan importante aplicar una y otra. O sea, y al final entiendo que es como una discusión pues, meramente académica, pero sí creo que sería bueno como pensar no sé, en alguna otra respuesta, que digo, es complicado, ¿eh? Porque y ni siquiera sé si la hay realmente, pero, o sea, ya siendo un tribunal real, creo que, o sea, no vería por qué alguna de las partes le interese, digamos, aplicar ciertas reglas, solo porque en unas expresamente se confiere al tribunal una facultad, porque en realidad el tribunal tiene facultades, digamos, amplias para conducir el procedimiento, ¿no? Entonces, ahí, digo, sería ver si es posible conseguir alguna otra respuesta. Em, Fíjate que tu Sorry Bottle, la verdad es que sentí que lo diste como con mucha firmeza y me gustó bastante. Ahí el único detalle que vi fue que como que te interrumpiste tú solito, o sea, te dijiste, lo empezaste a decir, después thank you, porque creo que como diciendo gracias a Santiago, creo, y después lo diste otra vez. Entonces, fue un mínimo detalle, pero bueno, en general me gustó mucho tu Sorry Bottle y en general tu pling, la verdad es que me gustó mucho, o sea, si tuviera que recomendarte algo, pues sería quizá preparar las respuestas a esas preguntas que pueden ser un poco complicadas. Y creo que eh, con eso estás lista. Em, y Martina, ok, igual un pequeño detalle, en algún momento dijiste, if the tribunal might follow me, yo ahí te sugeriría decir, if the tribunal could follow me, or if I could drive the tribunal's attention to tal, en vez de la palabra might. Yo cambiaría nada más el término might. Em, Me gustó que dijiste, respond cannot claim a surprise, o sea, ese tipo de frases como que son siempre, no sé, son frases que atrapan la atención del tribunal y siempre se agradecen. Creo que igual tienes muy buen pace. El tema de lo de las sites, que creo que dijiste que era una institución privada, eso la verdad no, o sea, no estoy seguro, o sea, eso habría que confirmarlo, pero bueno, eso ya nada más sería confirmarlo. Em, el tema de la reversibility de la cover sale, me gustó mucho cómo zanjaste el tema y que, ¿sabes qué? Pues eso ya está respondido en la PO2, entonces, ¿para qué nos metemos en brollos? Pero lo que sí quiero decirte es que quizá algún tribunal sí te puede intentar meter ahí y preguntarte, oye, pero a ver, o sea, háblame de si fue realmente razonable el precio de esa cover sale por el tema del descuento y de si realmente reflejaba las condiciones del mercado, ¿no? Eh, y bueno, en general creo que tienes mucha presencia, entonces igual creo que también, eh, al igual que Tice, creo que tienes muy, o sea, fue un buen pedido en general, creo yo. Em, el tema del World, ahí creo yo que sería mejor, digamos, usarlo para contestar un punto de Vale en particular, algún punto que consideres débil. Creo que aquí yo más bien lo sentí un poco em, como que está reforzando tu punto, pero sin contestar más bien a lo de Vale. Entonces yo te sugeriría nada más eso. Y ya, en general, pues muchas felicidades.
Muchas
Muchas
gracias por el
gracias.
feedback.
Muchas gracias, Milobatiux. Pues eh, antes que nada, quiero felicitar a las tres pleaders y el pleader por su ronda. Creo que fue muy fructífera para ambos equipos, entonces sé que la preparación oral es muy complicada, es extenuante, entonces, pues antes que nada, muchas felicidades, y espero que esta ronda les haya servido como a nosotros para seguir llegando, para seguir trabajando. ¿Van a ir a Viena?
Sí,
Ah, perfecto, entonces pues esperamos verlos por allá.
sí,
Eh,
obvio.
Habiendo dicho eso, a ver, déjenme, ya pasó con Thais. Ok, tu cache, bueno, antes de eso, déjenme hacer un disclaimer súper rápido y es, yo siempre les digo a los mutis de otros equipos, como coach, que los consejos que nosotros les podamos dar, siempre son en aras de que ustedes puedan mejorar, para que lleguen lo mejor a Viena, pero eso no significa que dejen de hacerle caso a sus coaches. Entonces, siempre, siempre, siempre quien debe de prevalecer, por decirlo así, son sus coaches y los consejos que ellos les den. Independientemente de eso, pues nosotros les damos o les tratamos de dar el mejor feedback posible, como uno como externo, que no los conocemos, no tenemos el gusto de conocernos. Entonces, tomen lo que crean que de verdad les sirve y lo que no, sin problema, deséchenlo. Y creo que esa es una recomendación que les puedo dar, no solo para ahorita, sino en general para todas sus siguientes rondas y premoves que tengan. Ahora sí, habiendo dicho eso, Thais, Me gustó tu catchphrase, creo que fue buena catchphrase, o sea, sí, como que me llamó bastante la atención esa catchphrase, estuvo interesante, y más que utilizaste justo un tema, pues muy relacionado con el objeto materia de la disputa, ¿no? Que son las orquídeas. Entonces, creo que eso estuvo bastante bien. 1:25 te aventaste toda la presentación, que fue tu presentación, el roadmap, la catchphrase, ta, 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 ta. Entonces, creo que es un buen tiempo, tal vez mejorarlo un poquito más, unos 10-15 segundos estaría increíble para que tengas más tiempo de meterte al fondo. Nosotros consideramos, o bueno, la filosofía de nuestro equipo es que siempre tienen que acabar en 1 minuto, 1 minuto 10 la presentación para que justo no les come el tiempo al final. También no saben cómo para reaccionar el tribunal arbitral. Hay tribunales arbitrales que están muertos, que pues los dejan hablar 14 minutos y son 14 minutos donde ya llega al minuto 10 11 ya no saben qué más decir. O pueden tener tribunales como yo que están, aquí en México decimos chingui, chingui, chingue, pero como que estábamos moleste, moleste y moleste y moleste y no los dejamos como proceder tanto. Entonces, lo que les diría es, intenten tener como eh, ay, se me fue la palabra, un speech, por decirlo así, de 6 8 10 12 y hasta los 14 minutos, dependiendo el tribunal que les toque. Y para eso lo van a ir leyendo conforme avance la ronda. Obviamente, pues de solo verle la cara a su tribunal no van a saber qué clase de tribunal van a tener, pero sí van a ir leyendo al tribunal conforme pase el tiempo de la ronda, ¿no? Entonces, eso, ok, algo que la verdad personalmente y también como que a mi equipo siempre les digo, a mí la verdad no me gustan ese tipo de frases como I see your point, I see your concern, I understand your concern, porque a mí, o sea, yo siempre saco esta anécdota porque a mí literal sí me pasó, o sea, cuando yo fui multi en su momento, por quererle copiar a algún equipo, porque para mí había sonado muy, muy bonito eso de I understand your concern. Lo quise sacar en una ronda interna. Y entonces el que fue mi coach en su momento, pues era medio rudo. Entonces alguna vez lo saqué y le respondí, I understand your concern. Y literalmente me contestó, It's not my concern, it's your concern. Y yo la verdad, pues como en ese momento, pues no, o sea, dije, ay, sí, órale, o sea, mamón, ¿no? Y como que no lo pelé. Total que, o sea, llegamos a París, vamos al Primus de ICC en París. Y a mí se me ocurre decir en mi ronda con un tribunal arbitral que ya ese sí ya era de abogado. Bueno, también mi ex coach ya era abogado, ¿no? Pero me refiero con más experiencia y tal. Y saco esa fresita de I understand your concern. Y para mi gran sorpresa, ella sí me contestó lo mismo. It's not my concern, it's your concern. Y me dijo, yo estaría preocupada porque no entiendas la diferencia entre eso. O sea, sí se portó como un tanto rude. Entonces, desde ahí sí quedé como traumado, por decirlo así. Entonces, yo normalmente a mis equipos les digo, no, ya no utilicen ese tipo de frases porque sí les puede tocar un árbitro o una árbitra que sea lo suficientemente grosera como para decirles eso. Entonces, mucho ojo con eso. Eh, ok, sí, aquí un poco lo que Lobato decía, el cocaunceleo. En algún momento vi que, o sea, que tú, Tai, no, no, sí, que tú, Tai, estabas como tú moviendo el bundle, como que Martín estaba un poco distraída. Ahorita voy a pasar al otro lado, pero luego, después, cuando Martina estaba en su pleading, como que tú, Thais, como que no, o sea, no sé si como que te desesperaste de que no encontrabas la hoja, yo qué sé, pero como se vio que levantaste todo el bundle y fue muy notorio en la cámara. Entonces, si en la cámara es muy notorio, entonces tienen que tal vez tener un poquito más cuidado con ese tipo de detalles, porque cuando ya tengan a su tribunal en vivo, si es que no han tenido ya rondas en vivo o en presencial, pues eso sí lo notan mucho los árbitros. Entonces, tal vez las invitaría a que trabajen un poquito más su counseleo. Este. Tal vez te invitaría, Thais, a trabajar un poquito más en el conocimiento del caso. O sea, no recuerdo bien por qué anoté esto. O sea, sí recuerdo que sí lo pensé. O sea, más bien, lo que no recuerdo es por qué lo anoté. O sea, hubo un momento donde. Creo que te pregunté algo o alguien te preguntó algo o tú solita, que empezaste así como, está en la PO2, página tal, y luego como que no la encontrabas y todavía dijiste no, y give me a second, o sea, como que ese tipo de cositas, pues sí lo nota el tribunal. Lo que te diría es, primero, no, o sea, no des a entender que como que estás perdida como con el caso. No es que no lo sepas, sino que no des a entender eso, pues, ¿no? Y segundo, pues se vale de pronto no, o sea, no tenerlo muy bien ubicado, pero para eso lo que te diría es estudiar un poquito más y vas a ver que sin problema, o sea, ya bien van a llegar con el caso memorizado. Entonces, solo que no, o sea, por el momento no lo hagas evidente y poco a poco va a dejar de ser evidente y ya no va a pasar. Entonces, nada más, ojo con eso. Ah, ah. Tuviste un par de fillers, creo que es normal a este momento, luego nos ponemos nerviosos. Entonces, solo como que ese del, por ejemplo, a mi equipo le pasa mucho el da para como que alargar la palabra de y pensar lo que van a decir. Entonces, solo mucho cuidado con eso. O sea, son pequeñeces, pero en Viena, pues, digo, si es su primera vez, todavía no lo saben, pero si no es su primera vez, pues saben que lo penalizan bastante, ese tipo de cositas. Entonces, ojo con eso. Me gustó mucho que sacaras el tema de separabilidad. Creo que en pocas rondas que hemos tenido han sacado ese tema de separabilidad y creo que por ahí hay argumentos bastante fuertes. Justo. Entonces, tal vez lo que te diría es refuerza un poco más ese argumento de separabilidad, porque, o sea, lo único que te pregunté fue, a ver, o sea, sí entiendo el tema de separabilidad, pero pues las partes acordaron que CIG gobernaba tanto el contrato como el agreement. No me convenció tu respuesta, tal vez lo que yo hubiera respondido es, o sea, el que las partes hayan acordado eso no brichea el principio de separabilidad. O sea, la separabilidad existe y es uno de los cornerstones del arbitration, justo a la party autonomy y al competence, ¿no? Entonces, con una respuesta tan sencilla como eso, yo creo que te hubieras quitado de problemas. Otro tribunal arbitral de ahí se hubiera agarrado y te hubiera, súper acabado. Entonces, pero creo que el hecho de que lo sacaras, o sea, desarrolla más ese argumento y creo que es un argumento bastante fuerte. O sea, me gusta, o sea, me gustó que lo sacaras, casi no lo hemos escuchado y la verdad es que también yo luego pienso, ¿y por qué no sacan tanto separabilidad? Pero creo que es un buen, o sea, es una buena línea de argumentación esa. Ah, 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 ah. Donde sí tendría mucho cuidado y ahí sí tal vez afinar un poquito más el conocimiento es en la parte de cuando te pregunté sobre la mediación, sobre el MAA protocol, porque la mediación no, o sea, no es un, como tal, un medio alternativo de solución de controversias que derive en coercitividad o que sea enforceable, ¿sabes? O sea, puede ser binding entre las partes, o sea, sí, sí es vinculante entre las partes, porque pues al final de cuentas es un acuerdo, pero eso no quiere decir que haya medios judiciales o extrajudiciales para, sobre todo judiciales, para hacerlos efectivos. Y eso es lo que diferencia la jurisdicción nacional y el arbitraje del resto de los mecanismos alternos de solución de controversias, que solo estos dos, y el arbitraje todavía en teoría, porque el arbitraje todavía te deja muchas dudas al respecto, pero digamos que en teoría son los dos únicos medios que sí pueden hacer enforceable el cumplimiento de un award o de una resolución judicial. Entonces, tal vez trabajar un poquito más en eso, cuidado con esa respuesta, porque yo creo que ahí sí tuvieran, o sea, un tribunal sí te acaba, o sea, entonces nada más trabajar como con eso. O sea, entiendo yo para lo que querías dar a entender, pero tal vez fue la forma en que lo expresaste o algo así, pero solo como que al final ese detalle, ese yo creo que sí lo pondría como main. Ah, 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 ah. Lo relacionaste con el lengua y sí, justo José te preguntó al respecto y también, para serte franco, tampoco me convenció esa respuesta, entonces, cuidado con eso. Pasaste a tu segundo issue al 12-21. O sea, eso ya es una cuestión de equipo. Ustedes saben, o sea, según su teoría, ustedes saben en qué momento deben de pasar. A mi parecer, yo creo que pasar al segundo issue en 12-21 ya es bastante tarde, porque les da minuto y medio más o menos para adresear todo un segundo issue. Entonces, y creo que lo de los TPF agreements no es tan relevante, pero de todas formas, con que tuvieras una ventana de 4 minutos tal vez, con eso yo creo que hubieras llegado súper bien a tu tiempo. Acabaste en 14:25, lo cual creo que estuvo bien, porque me parece que fuiste la más cercana a acabar, sí, la más cercana a acabar en tiempo. Este es tal vez un comentario general tanto para ustedes como para los míos. Eh, Mucho cuidado con el tiempo, sabemos que penaliza muchísimo el tiempo en Viena, entonces son rondas de práctica, ahorita no hay tanto tema, pero sí para que vayan midiendo bastante su tiempo. Eh, uh, 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 uh. Tu Survival 16 segundos, creo que estuvo bien. Nosotros tenemos la idea de que 30 segundos o menos es el margen ideal para tener un Survival o un Revival potente y que quede en la mente del tribunal. Sin embargo, yo creo que puedes mejorar el Survival. Creo que tu opposing counsel te dio dos que tres ahí ayudaditas como para decir, de aquí me agarro, ¿sabes? Entonces, nada más como que tal vez elegir mejor el punto al que vas a atacar. Fuera de eso, una vez más, muchas felicidades. Creo que, no sé, espero que todos estos comentarios te sirvan. Y la verdad, ya lo que ya dijo Lobato, pues lo replico. Tu pace era muy bueno, escucharte era muy agradable, el tono de voz fue bastante bueno. Entonces, la verdad, muchas felicidades.
Bueno, muchas gracias por el feedback a ambos.
No, a ti, déjame ya paso a Martina, a ver. Ok, tu roadmap acabó en 1.25. Nuevamente, tal vez sería replicar el comentario de Comentáis. 15, 10 segundos menos, creo que estaría ideal. Eh, Nada más, mucho ojo con el tema de avoidability y overcomable. Eh, yo lo, pre- yo lo preguntaría, digo, yo lo pregunté, perdón, porque es un tema que nosotros ahorita estamos explorando, si es lo mismo, no es lo mismo, tú dijiste que era lo mismo, tal vez no lo tenías como en el radar. Ahí tal vez ya les dimos una pista de cómo va el asunto, o sea, avoidable es previo a, overcomable es posterior a, ¿no? Entonces, para que lo chequen, probablemente va a salir en rondas más adelante y en rondas más complicadas o más técnicas, entonces tal vez sería buena idea como explorar esta parte. Me gustó el roadmap, o sea, pues creo que el roadmap fue muy straightforward, bastante bien. En tu caso, nuevamente desde la cámara se nota como que estabas volteando mucho a, si no me falla, es tu izquierda, como a tu izquierda y hacia abajo. Sí, es correcto. Sí, sí, sí. Entonces, lo que daba a entender a veces es que estabas como que leyendo. Y tal vez es algo que no quieres que el tribunal vea. No te estoy diciendo, no leas, en la medida de lo posible, evítalo lo más que puedas, pero tampoco memoricen, eso también es pésimo hacerlo, o sea, ya sé que luego es como muy contradictorio, o sea, ¿en qué extremo, no? O sea, o leo o memorizo, no, o sea, debe de haber un punto donde ustedes entiendan los argumentos y tan los entiendan que puedan desarrollarlos de tal forma que parece que están leyendo, pero le sale natural y sin memorizar. Entonces, sí, justo por ejemplo, ahorita lo volviste a hacer, Martina, entonces como que se nota, ¿sabes? De que volteas como hacia abajo y a la izquierda, entonces tal vez tendría un poco más cuidado con eso para que no sea tan evidente. Eh, ok, por ahí, eso ya es tema de forma. El Presign Arbitrator era yo y por ahí se te fue decirle a Lobato Mr. Presign Arbitrator. Entonces, son pequeñeces, o sea, a mí la verdad, pues no es como que me importa, o sea, pero luego en Viena sí son medio complicaditos con ese tipo de cosas. Y tal vez, o sea, lo que nosotros pensamos como equipo es, o sí, nuevamente como en la misma línea de lo que decía Thais, es, eh, cuando te vienen varias preguntas de distintos árbitros, lo ideal es que siempre, 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 por respeto, por mera formalidad, como quieras decirlo, le contestes primero al presiding arbitrator y ya luego te vas con la segunda persona, bueno, con la persona que te preguntó primero. O sea, por ejemplo, Lobato te preguntó algo, yo pregunté dos cosas, entonces tal vez lo ideal sería que me contestaras a mí primero y después pasaras con Lobato. Si fueran los tres árbitros, en este caso José, Lobato y yo, que el Lobato preguntara primero, luego yo y al final José, contestarme a mí primero, luego a Lobato y luego a José. O sea, ahí sí aplicar el orden, pero nada más es eso. Ah, 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 ah. Ok, pasaste en 9.15 a tu segundo issue. Creo que La verdad es que yo no soy el coach especialista de méritos, pero creo que es un tiempo bastante razonable, o sea, no estuvo mal para que pasaras a tu segundo issue, entonces bastante bien. Oh, nuevamente, ojo con el tiempo. Al 14:13 pediste un minuto. O sea, ya se te había pasado el tiempo y todavía pediste un minuto. Entonces, mucho cuidado con eso. O sea, yo que tú ya, si ya había visto que ya me había pasado, ya mejor wrap up y acabas. O sea, más vale, ¿no? Porque aquí va el segundo comentario. Te concedí el minuto. Y de todas formas, te concedí el minuto y en teoría debiste haber acabado en 15:13 y acabaste en 15:24. Entonces, como que para el tribunal sería, bueno, o sea, pues ya te concedí el minuto y de todas formas, como que te pasaste. Entonces, cuidado con eso del manejo del tiempo. Si ven que se las está comiendo el tiempo, o sea, pues, no es lo ideal. Pero si de plano ven que se les está comiendo el tiempo, lo más recomendable es ya, o sea, considerando el tiempo, córtenle hasta donde llegaron y ya ni modo. O sea, lo demás, pues ya se quedó sin explicar. O sea, obvio lo van a castigar, pero creo que castigan todavía más el tema del tiempo que lo que faltó por explicar. Que de todas formas no es lo ideal. Entonces, solo como que para que lo consideren. Tu Revoral duró 26 segundos, creo que todavía estuvo dentro del margen aceptable, digamos, o sea, menos de 30 pues. No, no, no fui muy fan, o sea, no es que estuviera mal, creo que lo mismo que, o sea, es el mismo comentario que con Thais, o sea, puedes, o sea, puedes escoger un punto más o sea, pudiste haber escogido algo más para atacar a tu contraparte, algo más fuerte. Recuerden que la impresión que le dan al tribunal, sí, o sea, más bien, el tribunal siempre se va a quedar con la impresión, principalmente que le dan al principio de la ronda, cuando están presentándose, y al final de la ronda, cuando concluyen y sale el rival o sub-rival. Pueden hacer una ronda espantosa, horrible, y no porque este lo haya sido, sino, o sea, para que lo tengan en cuenta, pueden hacer una ronda espantosa, horrible, que un día malo, lo que quieran, pero si su rival o sub-rival es increíble, con eso se queda el tribunal. Y créanme que se le olvida todo lo demás. Entonces, nada más como que para que lo tomen en cuenta y ya. Básicamente sería eso. Martina, también muchas felicidades. O sea, la verdad, las dos son bastante buenas. Creo yo que van por muy buen camino. Y estoy seguro que para Viena van a llegar súper fuertes.
Bueno, muchas gracias.
No, a ustedes.
Chicos, bueno, muchas gracias por la pleading, muchos éxitos. O sea, la envidia que me da que se vayan a Viena.
Oigan, nos gustaría tomarnos una foto, no sé qué les
Sí,
parecería.
obvio.
Gracias.
Sí, obvio.
A ver, déjenme ponerme el saco por eso.
Ok.
No, y quién sabe, yo sé, nosotros, además los coches todavía estamos en stand-by también. Entonces,
Ah, ¿no saben todavía? No.
sí, entonces todavía estamos viendo, pero ojalá, ojalá.
Pero ¿cuántos coaches son?
Ahorita somos tres, Lobato, que era el otro árbitro,
Sí.
tu servidor y otro árbitro que digo otro árbitro, otro coach que ahorita estaba trabajando, entonces no pude entrar a la ronda.
Y no saben, ustedes dos no saben si van todavía.
Eh,
Yo sí, porque yo ya compré el vuelo, entonces, bueno,
Ah,
espero que sí.
está, bien.
pero los otros dos estamos todavía veremos. O sea,
Bueno,
nuestra
ojalá
intención
que
es
puedan.
ir, pero como nos tardamos tanto en comprar los vuelos, pues ya se elevaron muchísimo, entonces lo estamos todavía tanteando.
¿Alguien puede tomar la foto? Porque nosotros tenemos que salir.
Sí,
Buena
sí,
pose.
yo lo hago.
Ah,
Mil
Ok,
gracias.
sonrían. Ahí está.
Gracias.
Vamos. Bueno, chicos, muchos éxitos, muchas gracias.
Mil gracias.